Welcome to Guardians of Innovation, Patent and Trademark Law.
Welcome back to Guardians of Innovation with Vincent LoTempio. Vincent is a registered patent attorney with over 25 years of experience helping inventors and entrepreneurs protect and profit from their ideas. I'm Kevin Rosenquist, and today we're exploring one of the more practical ways to make money from your invention without starting a company yourself: licensing, one of the most common ways inventors turn their ideas into income. Vincent, welcome back.
Hey, it's always great to be here with you.
Absolutely. So the licensing thing, yeah, this passive income, we all want passive income, right? Wouldn't that be nice? Can you just start by explaining what it means to license an invention?
Yeah, so it's kind of like you're renting it to somebody else. It's like a rental. You're getting to use the house when you rent your apartment, right? This is you get to sell a product, and that you have the right to sell that product, and that's always the holy grail. Everybody wants to sit home and collect checks. My father used to tell the story about that he went into and he was an inspector for the city, and he went in to inspect an apartment, and there was apartment above it, apartment below it, and he was supposed to inspect the plumbing. He goes, "Well, where's all the bedrooms and everything?" He said, "Well, that's the one below. I'm just turning this apartment into a bar and a pool room." And I'm like, well, he's like, where did you get all your money from? He goes, I invented the thing that you get in your binocular case or something else, the desiccant little bag of desiccant stuff. So every time somebody puts one of those in a product, I get 10 cents or something. And he was a multi-millionaire, the guy. And so that was my first experience when I was a kid, just learning about what a licensing agreement can do for you.
Wow, yeah, that is the dream, I suppose, for a lot of people, especially inventors in this situation. Why might an inventor choose licensing instead of building a business around their product?
Well, a licensor is the person that's giving out the license, and a licensee is the person that's getting the license. And an inventor, you're the mother with a new baby bottle nipple. You don't know how to manufacture, market, or distribute a product, and you have the ability to do that. And what your hope is that somebody else will like your product enough that they'll do all that stuff. And of course, when you're making that deal, if you're George Foreman, and I keep using this example, and you put your name on a product, you have a lot of leverage there. If you're just Joe Schmo and you've come up with a product, I mean, what leverage do you have? They're gonna, that company that's gonna manufacture, market, and distribute that product for you and pay you money is gonna have to really like that product, and they're gonna have to be pretty sure that you have control and you own that product, and that you have the intellectual property rights to it, you have the patents, the trademarks. You own the name George Foreman, and you're allowed to put it on there. So, those are some of the things that you have to look at when you're talking about licensing agreements.
So within these licensing agreements, what are the basic parts of it, and that you feel like every inventor listening should understand?
Well, it's a contract. Right. And it's and like anything that you write or you talk about, when I ask questions, the first thing, that the nuns taught me when I was in school years ago is to analyze something: who, what, why, where, and when, right? And that's basically what the contract's doing. It's like, who are the parties? What is the agreement? What are we going to do? How much money is going to be transfer hands? What are you going to charge it? Who's going to own it? Why are we doing this? Those are basic things that you have to address. Now, there's so many legalities over the years. And I talk about people collect stamps. I collect licensing agreements. I have hundreds of them in my computer. And no two licensing agreements are the same, because no two parties are the same. No two people are going to agree on the same things. So
Mhm.
I like to say, look, we start with a memorandum of understanding, with the basic principles. How much, what, what you're going to do and who's going to own what. Those are the basic terms. And then we can figure out, as lawyers, all the minor things, what rights do you have to enforce it? What's going to void this deal? When could you hire an accountant to go in and look at the books? What if we make a certain milestone on a certain date, do we get an extra $1 million? Things like that, come in afterwards. But the first major points, are we really interested in doing this? And this is how much money we're looking to do, are the things that, you want to get cleared up right away. And then, of course, when you're negotiating that price and when you're actually negotiating the terms of the contract, the license, that's when we go into the deep dive.
Are there is there a typical way that royalty payments are generally structured?
Like I said, no two are the same, but yeah, usually it's quarterly or monthly or, biannually. It could be anything that the parties agree to. Maybe it's just a lump sum payment. We just did a licensing agreement where they made two big lump sum payments, and they were one of the terms that you look at are geographic area that you can use it, so maybe it's in the West Coast, maybe it's just in these three states, and then if you want to expand into the East Coast or the Midwest or in the European, you know what's it called, the European environment, the why am I drawing a blank, I'm sorry on this
The
one.
European Union?
Yeah, well, yeah, the European Union, or the whole area of Europe. If you want to expand there, then those terms could include, okay, X number of dollars per state, per union, per time, so yeah, it could be negotiated down to, anything really that you can agree to, that you both can agree to. Then, some of it can get very, very minute. I mean, we got all the way down to a bottom of an agreement, and one word was argued about, and both sides, this is a deal breaker. If you don't, that word's in there, we're not going to do it. If it's not in there, we are going to do it. That was after, when you red line a contract, it changes color each time you do it, going back and forth. This one looked like a Christmas tree going back and forth so many times, and it came all the way down to one word. We finally negotiated and worked it out between the two, but yeah, it all comes down to being able to agree. Now, the problem is with new entrepreneurs and startups is they don't have a lot of leverage, and a lot of these, product development companies say they're going to do all these things that you can't do, and they never do any of it. So, inventors really have to be careful to protect themselves. They have to be street smart. They have to understand that a lot of these companies are going to try to take advantage of them, that these contracts are going to be written so one-sided that it just doesn't make any sense to sign. But other times, maybe if you're going to get published in a new book, right? And the contract is really one-sided towards the publisher, but maybe just getting that first book out will turn you into a international, author. And without that first shot at that first book being published, you wouldn't have never got that shot. So
Right.
yeah, you always have to look at your circumstances and decide what's best for you. And that comes with being street smart and book smart. Book smart is understanding what are the norms in the industry, what does it cost to do this, what is normally received in this, what's reasonable. And then books and street smart is figuring out, seeing the red flags where they're trying to take advantage of you and steering away from those type of people.
What are some of the more common mistakes that you see inventors make when they're negotiating license deals?
Well, I think a big part of it is, um, the mistakes are when they first start, the way that they contact the companies, and the way that they're not prepared to have it protected before they talk to the companies. So I think the big part of it is they have something filed, at least a provisional, before going in to talk to these companies. And the other part of it is of thinking that, you can just show them your idea and it's just gonna fly. You really got to be able to anticipate all the needs and all the questions that the companies are going to have and be prepared to answer it. And to go into one of these meetings unprepared is just a recipe for disaster. And another thing is just trying to email it generally out there to a bunch of people without actually looking somebody in the face. And, I like, inventors to, even if it's their first time, say, introduce themselves as a product developer, as an entrepreneur, product developer, toy developer. And I need to speak to somebody that actually has the authority to make a deal. I think I have this new um, product that's going to clear the ice off the airplanes and save millions of lives. I think the guy who's going to buy this for the airlines would be a good guy to sit down and talk to, not just an email generally to an open box. I mean, I think
Yeah,
those
to
are
info
some
at
of the things. Yeah,
airline.com. Yeah, yeah.
yeah, it's not going to go anywhere.
Right. Yeah, totally. You mentioned red flags before. I'm curious, like we all see those commercials, like you've got an idea, call us, or ads on the web. What are some of the red flags that an inventor should look for when they're trying to talk to somebody about, getting licensing rights or any of these other things that might be signs of being taken advantage of?
Yeah, right away they start asking you for money and they're really pressing you for money,
Mm,
right? If they liked your ideas so much, why not just invest in it themselves and give you a piece as on a contingency fee basis instead of having you pay for all these advertising and all these things that they want you to do. And then the other part of it is start asking them questions like, well, how many people have given you money and how many people have made money from you? And if they start backing away from a simple question that by law they're required to answer, that should be a red flag. That's somebody you don't want to talk to.
yeah, I would say so. That's a good one. I'd lead with that for sure.
Yeah. And if they're like backpedaling and they're not answering it, I mean, you know, you feel that gut in your feeling, that you're feeling in your stomach, and you just kind of know, and
Yep.
and this is all business. Don't take it personally. Just say, yeah, I'm sorry, it's not going to work. I'm going to go on just to the next guy.
Hmm. Yeah. I would imagine having a patent or at least a pending application would strengthen an inventor's position in licensing negotiations. Yes.
Absolutely, but they're still going to want to see an actual patent. They're still going to want to see if you don't have the patent, the search to say you have a shot at getting it. And it goes all the way down from the patent itself to beta testing, having surveys of people that used it. It's a full gamut of things that you have to do to manufacture, market, and distribute. And starts with the patent to protect it, but still, to answer all these questions, how much does it cost to manufacture? What's a good price? I keep going back to Wayne Fromm. I learned so much working with him, the inventor of the selfie stick. And he said, like, we had to have it started for 1999. That was the price. So I had to work with these manufacturers to get it so we can make money. And the general rule for making money is 1 to 5. If you can sell it for 20, you got to make it for 5, right?
Hmm.
Or like, yeah, 25%, not 25, 20%. So you got to multiple by 5. What's times two? 5 times 2 is 20, so $4 each, right? So you'd have to do, if you're going to sell it for 20, you got to be able to manufacture it for 4, so everybody can
Hmm.
get paid along the way. There's manufacturing, there's transportation, there's advertising, there's storage, there's distribution prices, there's you have to get paid, right?
Hmm. Oh, that's interesting. Yeah, that could be tricky, I suppose, in certain products for sure. Can you share an example where licensing worked really well for an inventor, and maybe what made it so successful?
Well, yeah, again, the whole idea of licensing is so you don't have to manufacture, market, and distribute. And I had a client, one of my first clients, and he worked out a deal to get paid quarterly, an X amount, 6 figures. And he had come up with just a simple invention on how to put lights on the side of the outside of the wall. And it's more of a something of an invention that, unless you were an electrician, you don't even know what it is inside that wall and what's going on. And he came up with this great idea, and he was selling it, and a company approached to him, and basically said, look, we just want to buy your patent. We don't want you to compete with us, and we're just going to pay you X number of dollars and for X number of years. And I even remember his kids coming in after he died, and we had to work out all the where the payments were going to go, and it was still extended out into his kids. So that was one that always kind of stuck with me. It was just an electrician. He didn't really have any um experience in inventing things, or in selling them, or being able to do it, and he was able to work out a licensing agreement.
So basically, if you're in a position where you can manufacture or know how to get it done and you have that sort of knowledge or those sort of connections, perhaps it is best for you to actually create the product, create a business, whatever. But if you really don't even know where to begin, is it safe to say that the licensing might be your best bet?
Well, the problem with the licensing then is, if you're just beginning, is you don't have any type of a track record.
Right.
If I have a track record like Wayne Fromm, and I come up with a new, he's already got a deal. I keep using him for an example, but he's already worked with Disney before. He's already worked with Mattel, and if he's come up with a new idea, they're going to get on the phone and listen to them. But
They'll
there's a
listen. Yeah.
long line of
Hmm.
people with new toys that they think they're going to be the greatest toys in the world, and maybe they will be, but um, but it's gonna be a long line, and you're gonna have to fight your way through a lot of minutia to get there. And but if your idea, like I talked about before, is to get the ice off of the airline wings that can work better, there's probably not a lot of people coming up with that idea, and there's a better chance that you're going to get your foot in the door and talk to them. So I think it's relative to your ability to make a presentation and get your foot in the door. And that's another thing. Maybe you have to hire an agent to do that. One of the richest people in the history of the world was Howard Hughes. And what did Howard Hughes invent that made him so much money? I mean, he made money over the years on countless things, but the big thing was he invented if you saw the movie, he invented a drill bit to drill for oil. And he wouldn't sell those bits to anybody. He would only license them, to people to use. And he says, I'll always give you a new one. I'll always make sure it's sharp and always have it, but I'm always going to own it. And you're going to have to pay me to use them. You can't just buy it and use it. And so there's a lot of different ways that you can make money using a licensing agreement. And it is like the holy grail of what everybody wants to do, but it's not easy. And in order for you to do that, even if you can't do all the manufacturing, marketing, distribution, you're still going to have to be able to negotiate and discuss what it's going to take for them to do it, and why it's going to be advantageous to them, and convince them. So you're still going to make have to make that presentation.
I remember the movie The Aviator, right? That was the
Yeah,
movie.
yeah,
Yeah, yeah. I
yeah. And
didn't
if you
remember that about the
remember, they
drill bit.
talked
I didn't.
about, the
It's
drill
been a
bits.
while
Yeah.
since I've seen that, but I didn't remember that. That's funny. All right. Well, thanks for listening to Guardians of Innovation with Vincent LoTempio. If you have an idea you'd like to protect, or you're exploring licensing opportunities, Vincent and his team can guide you through the process and help you avoid costly mistakes. Visit LoTempiolaw.com to learn more. And don't forget to subscribe, leave us a review if you found today's episode helpful. We very much appreciate it. Vincent, always great to see you. Thanks so much for your time.
Thank you. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.